You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we're talking about claims when it comes to Bank of Mum and Dad loans for property purchases. It's an issue that we are starting to see increasingly across family law. And to discuss the problem, we have Kate Booth, Head of the Family Department at Midlands-based Brindley, Twist, Tafft and James. It's lovely to have you on the podcast, Kate. Thanks very much indeed for joining.
Thank you, David. It's lovely to be here.
I know this is a topic that comes up in your workload, hence why we have you on the podcast discussing it. But in the first instance, tell us about yourself, tell us about the firm, what kind of work do you do before we move on to the meat of the discussion?
Absolutely. So, yes, I'm a solicitor at Brindley, Twist, Tafft and James. We are a full-service law firm based in Coventry, and we've got offices in Warwickshire as well. I've been dealing with family law for around about 20 years now, generally dealing with divorce and financial remedies, private law children, cohabitation matters. So, yes, quite a lot of family law.
So, we're talking about claims when it comes to this issue where son, daughter looking to purchase a property, and we know what property prices are like. We know it's very, very difficult to raise that deposit, get on the property ladder, and we are increasingly reliant, the stats are all out there, on the Bank of Mum and Dad. However, when that relationship breaks down, there is an issue because we are starting, or you are starting to see claims where the parents then looking to get some of that money back from the transaction.
We do see a lot of clients, and it seems to be increasing month on month, really, where people are coming to see us and there are issues around loans that have been funded by family members. It tends to be very common in connection with purchasing the family home. Obviously, we've got the difficulties and the very obvious issues in respect of the housing market, increasing property prices. We've got mortgage rates that are obviously very, very high, and people are really struggling to get on that property ladder and even to move up it. So that can be a really big focus when people are trying to purchase their first home. It's not even really necessarily just to do with loans for the purchase of the property. I've seen cases where people are borrowing money from the family to fund the wedding, fund renovations on properties or other large expenditure. Even funding fertility treatment can be something where parents are willing to help out. The difficulty does often occur when what was an informal arrangement between family members initially is then looked at in a slightly different light when people separate. A lot of the time, what was a very flexible arrangement, perhaps with no arrangements for interest or specific repayment terms, all of a sudden solidifies when people are divorcing and trying to decide where the assets should be split.
We're going to talk through some examples. I know that we're not going to talk about specifics, but sort of a general overview of this issue as well. But what are the laws and the precedents that kind of cover this then?
I think one of the real issues is whether or not this money is going to be classed on separation as a gift or a loan. There is often an arrangement when parties borrow some money initially from parents that there won't be any specific terms for repayment. It can often be the case when parties are separating that suspicion will develop. What was seemingly agreed or a non-issue whilst they were in happier times can become a significant area of dispute when they separate. We will often see one party claiming that funds advanced by their family member must be repaid. The other party will often say it was only ever a gift, it doesn't need to be repaid. The law then needs to draw the distinction between whether the funds were a gift or a loan. If they were a gift to the parties, then they will generally form part of the matrimonial pot of the assets that are going to then be distributed on divorce. If they are deemed to be a loan, then they are a liability that does need to be repaid. They'll then be deducted from the total amount of assets that are available, and clearly then there's less to go around. A lot of the time, these loans can represent a significant proportion of the assets, so it does really make a difference as to whether or not it's an asset that's going to be split or something that needs to be taken out of the calculations altogether. The issue can then become further complicated in family cases where we have this distinction between what we call hard loans or liabilities and soft liabilities. Liabilities that are deemed to be hard are things like mortgages, credit cards, loan arrangements, or commercial loan arrangements, and they are clearly liabilities that do need to be repaid. Soft debts generally are things like loans from family and friends. There might not necessarily be formal repayment terms. And generally, if the court finds that a liability is a soft debt, then it's up to the discretion of the judge whether or not that needs to be taken account of in the assets to be divided, or whether effectively it can be ignored and those monies can be split between the parties. In 2022, the case of P&Q gave us some very clear guidance on the factors that might point towards whether a debt is hard or soft. So when we're looking at hard debts, we're looking at things like commercial debts to a finance company, situations where the terms have the feel of a normal commercial arrangement. Where there is a written agreement, that will obviously be of evidential value. And where there are written demands for payment or even the threat of litigation to recover that liability. Where the creditor has started to enforce the terms or there isn't any significant delay in enforcing the terms. Another important one is whether the amount of money is such that the creditor is less likely to waive the need for repayment. So on the flip side really of those pointers towards what would be a hard liability, you've got the pointers which might suggest that a liability is on the softer end of the scale. That tends to be things like debts to friends or family members, particularly when the parties remain on good terms. Where the debt arose informally, so the terms don't have that feel of a normal commercial arrangement. Where we've got no documentation in writing, no evidence of that agreement or no demand for payment, and a delay in enforcing the debt. And again, similar to the pointer for hard debts, if we've got an amount where actually it's a bit more likely that your parent or your friend is more likely to waive the need for that to be repaid. So it's a case often of the judge looking at all of those circumstances and balancing whether or not, in the context of all of the relevant issues in the case, does this debt appear to be something that is hard, that is going to be enforceable, or is it more of a soft loan that actually the need for repayment is not as strong?
What comes to mind here is the conversation that you have when you're instructed, because you're not unlikely to be contacted by the claimant. You're more likely to be dealing with this as part of a separation, aren't you? So what kind of conversations are you having with the parties, and how are you explaining what their obligations are here? And how are you reconciling those challenges between the person that it feels obligated to give that money back and the person that is saying, no, we don't need to do that? It's
very often a case of reviewing all of the factors, having a look at that list of whether or not a loan is likely to be considered to be hard or soft, and working through that. I mean, obviously, when you've got clients and parties within divorce proceedings, particularly contested financial remedy proceedings, there are going to be lots of areas of dispute. Where I'm acting for the person whose family has advanced the money and who is suggesting that it does need to be paid back, we will be looking at trying to get hold of some evidence that supports that it was a loan that does need to be repaid. So looking for things like documentary evidence at the time, have the parties entered into a written agreement, are there even emails or text messages, records of discussions between them that might point to the fact that this is something that needs to be repaid. On the flip side, if I am acting for the person who is potentially now saying it was never a loan, it was only ever intended to be a gift, we need to look for things like, is there any documentary evidence that supports their position? Has the other person started repaying this? Have the parents made any demands for the money to be repaid? I have had cases where my opponent has provided very questionable documents, handwritten notes where the dates don't necessarily seem to match. So it is often a case of just picking through that evidence and seeing what there is to support each contention, whether it is a hard loan or a soft loan. We often see the case that parties will, when we're going through the disclosure process, have made really large payments to a family member shortly before the issue of proceedings. A lot of the time that will come out when we exchange Forms E, and we can go through the bank statements and see those significant payments being made, and we can ask questions on those and request further evidence. In some circumstances, it might be appropriate to consider whether or not the family member needs to be involved in the proceedings and be invited to intervene and become a party. The difficulty here is it can be really lengthy and it can be very costly. We've got an extra party in the proceedings and all of the associated legal costs that come with that. We've also got the issue that the general rule that in family proceedings that there is no order as to cost doesn't apply for family proceedings. So it can be a very risky strategy. The case of TL and ML from 2005 does set out some guidance about the involvement of an intervener. It's generally related to the specific ownership of a property, but it might be relevant where there is a liability. So that case points to the fact that third parties ought to be joined into the proceedings at the earliest opportunity, and they should be given the opportunity to plead their case fully, as should both of the spouses. And ideally, in the case of TL and ML, the issue should be heard as a preliminary matter before the FDR, so that that issue can be clear to the court and can inform the parties when they are negotiating at the FDR. However, I have found that sometimes the nature of the FDR can mean that where this is an issue, the party with the deeper pockets might simply refuse to address the issue. The parties can't be compelled to settle at FDR. So I have come across this causing quite a bit of friction in some cases. And ultimately, it hasn't been able to be dealt with at the FDR and has needed to proceed to a preliminary issue hearing, thereby increasing everybody's costs significantly.
And presumably, if we're talking about loans to purchase property, for example, some of these loans are going to be quite sizable, and depending on the length of the relationship, it could constitute a significant element of the assets.
Absolutely. I've had cases where it's been clear at quite an early stage that the funds that have been advanced are going to represent a really significant proportion of those net assets to be divided ultimately in the divorce. In those kind of cases, the issue of whether or not this is a hard debt or a soft debt are really going to be central. It could be the difference between there being a substantial pot of assets to be divided, allowing both parties to rehouse themselves comfortably in owner-occupied property, or they may have no option other than to rent for the foreseeable future. So they can be really, really significant issues.
And so what are the lessons from cases like this? How can we best advise clients as practitioners?
I think a lot of the time it's going to come down to education and making sure that people are aware when these monies are advanced right at the outset, that they know what the situation is going to be. The best protection really is always going to be for the parent, the family member, to register a charge over the title to the property. They can then be clear that that loan is there to be repaid, and there is evidence at the land registry that is everybody's intention. We can also think about parties entering into pre or post-nuptial agreements around the time that these loans are made, because that can then offer them some really very clear protection. We can also look at declarations of trust. So a parent might not necessarily want to register a charge on the property, but if they are loaning that money, it's often advisable for them to enter into a declaration of trust with their child and or the spouse to make sure that there is a clear record of what everybody's intention was at the time. Less formal agreements, such as notes between the parties in writing or evidence through emails, are more likely to be subject to challenge. So it really is a case of making sure that everybody's intentions are recorded at the time, just to make it so much clearer when it comes to divorce proceedings, what the parties' intentions were and how the court can best approach that. Ultimately, the court will always be looking at ensuring the parties' needs can be met. But where we've got evidence that a loan is a hard debt and has always been intended to be repaid, then that's going to be very helpful in reaching the crux of the matter.
I mean, we're at a point in time, and we've done other podcasts about cohabitation as an example, and I appreciate that this is going to apply as equally to married couples as it does cohabitees, but thinking very specifically about property, 1 in 3 first-time property purchases are conducted by cohabitees because as we've talked about, it's simply unaffordable to buy by yourself. So this is presumably going to be an issue that we'll see more of in the future. Do you as well, just looking into your crystal ball, think that we can tackle this in some of the cohabitation reforms that we're hoping to see in the next couple of years?
I think really it is an issue that just permeates whether people are married or cohabiting. It's always going to be very important to make sure that everybody's intentions are recorded at the outset, but certainly going down the cohabitation reform route, absolutely, I would hope that this is something that can be covered in that. But I think my ultimate advice to people is going to be make sure you record the intentions, make sure you think about it at the time you're loaning or providing that money so that your intentions are clear and the court can take account of those at the point of separation, be it in a divorce or a cohabitee matter.
What is clear from the course of the discussion is that you're obviously seeing this in more and more of your work. It's not an issue that's going to go away, and as practitioners, it's one, something that we need to be aware of, and two, something that we need to keep a close eye on the case law around, I suspect, Kate, because like anything in and around this space, I suspect it will change over the course of the next few years.
Absolutely. I think we need to watch this space.
It's been fab to have you on the podcast. I really, really appreciate you coming on and sharing your insights, sharing your thoughts. So thanks very much indeed for joining.
Thank you, David.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on today'sfamilylawyer.co.uk. Thank you to Kate. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at today'sfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.